Hello and welcome to the Tennessee Informer. Thank you all for being with us. The Supreme Court is scheduled to begin hearing oral arguments in the Trump v. Barber case concerning the issue of birthright citizenship found in the 14th Amendment. Like so many contentious issues in our country today, the 14th Amendment is a factor. In fact, the 14th Amendment, through the Due Process Clause and Equal Protection Clause especially, have factored in most of the controversial issues in our country in the last 80 years. It has become the single most impactful amendment in our Constitution and has been allowed to practically remake the Constitution. But was that the intent and the understanding of the 14th Amendment when it was ratified by the states in 1868 during Reconstruction after the war between the states? How did the court view it for nearly 60 years after its passage? How and why did that change? What damage has that change done to our country and our Constitution? Here to discuss this very important issue is attorney and constitutional expert Jeff Cobble from Greenville, Tennessee. But first, a word from our sponsor, LifeWave, a unique product that uses light reflection to activate the body's own natural energy, supporting healing, improving performance, and combating aging without drugs or stimulants. Check it out, and we'll be right back with our guest, Jeff Cobble.
Light, the energy of life itself. Since the beginning of time, light has sustained us, fueled our growth, and shaped the world. Even Einstein recognized that everything we are is made of light. But what if we could harness the light within us, not just to live, but to renew, restore, and rejuvenate? Introducing LifeWave X39, the first product in the world that activates stem cells using our body's own light. Backed by clinical research, multiple patents, and over 10 years of stem cell research, a revolutionary wearable light technology that unlocks the power of activating our own stem cells with a single, safe, affordable, non-transdermal patch that puts you back in control of how you look, feel, and perform. Unlike drugs or chemicals, X39 works naturally, awakening your body's ability to heal and thrive. It's time to unlock your full potential, restore your vitality, and embrace a healthier, more vibrant you.
And now back to our guest, Jeff Cobble. Thank you for joining us. How are you doing tonight?
I'm doing great.
Really appreciate you being with us. I think we've had you on a few times, and you put out great information every time. So we do appreciate. We know you have a busy full day, and we appreciate you and your staff facilitating this, especially after hours. So let's get right to the 14th Amendment. I know you deal with it quite a bit in your practice, being an attorney. Now, you're an attorney, and as I mentioned, you're a constitutional expert. I guess, but to clarify that, you're a constitutional expert despite the fact that you're an attorney, because I would assume that most of what you've learned about the Constitution you learned on your own and probably not in law school. Is that accurate?
Well, most of what I learned about the 14th Amendment, that is correct, I learned not in law school. All law schools, it's the dog and pony show. And, it's going to be case law. They're going to direct you to the most recent cases. They won't even question. There's never even a question as to the ratification issue and so forth. So, yes, you have to kind of learn on your own.
Right. So what was the intent and understanding of the 14th Amendment when it was ratified by the states in 1868 during Reconstruction after the war between the states?
Yes, you have to, everything that you analyze about the Constitution, you've got to understand time and place. Culture has a lot to do with it as well. But obviously we have three amendments that are called together the Civil War amendments. They're post-Civil War. The Civil War, the war between the states is what generated the strife, of course, in the country, and southern states seceded. The Union said you can't secede. They claimed that you couldn't do it, and that's one of the things actually that plays into how we analyze this 14th Amendment issue. If the southern states in fact seceded, then I think you have a little bit of a different analysis. But the federal government took the position that you can't secede. So, but anyway, the back to the real question. There are three amendments: 13th, 14th, and 15th that are all called post-Civil War or Civil War amendments. The 13th Amendment, of course, abolished slavery. 14th Amendment, the one that we're talking about here, did several things, but the most important of which it's known is in Section 1 of the 14th Amendment, in which it establishes a dual citizenship between states and federal government. You can be a citizen of the state and the federal government. It addresses the concept of naturalization. If you're naturalized, or if you're born here, birthright citizenship, then you can become a citizen. And then we have these clauses, as they become called: the Equal Protection Clause, the Due Process Clause, a Privilege and Immunities Clause. 14th Amendment is right in the middle of all of those, and it's highly, highly litigated. Probably the 14th, in my opinion, maybe the First Amendment also is a close second, or maybe a close for first, but it's one of the most litigious and most often cited amendments in the entire Constitution. So the issue is because of equal protection and due process clause, and how everyone who wants to claim any right under federal law has to get there through the due process clause and the equal protection clause, and then they want the states to be bound by the same clause, and that has to do with the incorporation doctrine, which I think we want to talk about tonight. But that's the basic issue there. And of course, the 15th Amendment then gave the right to vote to the recently freed slaves. So it's important to understand that the actual purpose of the 14th Amendment was not in general to give rights to all citizens, or to allow the states to be bound by the federal government or the federal Constitution. The sole purpose of the 14th Amendment, with its actual text, is just to allow the recently freed slaves. It doesn't say recently freed slaves, but that's the purpose. The intent was to allow them to not have their rights taken by actions of the states that they claimed did not secede. So
So
that's what
and there was the Civil Rights Act of 1866, and if anybody's never read that, if you read that and you read the 14th, it'll be obvious to you where that came from.
That's right.
And I think the understanding from a lot of people at the time was, okay, yeah, if we just passed this Civil Rights Act, a future Congress could undo it, so we want to put it into the Constitution.
Right.
So, now, let's talk about the ratification process, because that's laid out in the Constitution. It's pretty cut and dried, but I don't know that they actually followed that too closely.
Well, they did not follow it very closely. Amending the Constitution, of course, an amendment is by its very definition an amendment to the Constitution. And in order to amend it, you have to first have it be proposed by both houses of Congress. And so the House of Representatives has to ratify it there by 2/3 majority in the House. The Senate has to ratify it by 2/3 majority. And then if and when that happens, then it's sent to the states, and then 3/4 of the then existing states had to ratify it. It's my position it was never properly ratified in the House, proposed and ratified, never properly proposed or ratified in the Senate, and also that it was never actually ratified by 3/4 of the states. So,
and why do you say that?
Well, it depends on how you count. It's always a fun issue to decide how we count things and what words mean, of course. But let's start with this idea. First of all, the southern states that had seceded had been readmitted to the Union, and many of them had actually participated in the ratification of the 13th Amendment.
Right.
When it came to the 14th Amendment, there was a decision by the Senate, particularly House and Senate, but the Senate I think has the loudest spokesman, perhaps. But they denied seats to the representatives and senators from the southern states. So it's a very interesting thing. How can they be allowed to participate in the amendment process for the 13th Amendment, but not allowed to participate in the 14th Amendment? So if they're denied a seat in the Senate, it's my position that if the southern states and their senators would have been accepted and been able to be present and cast their vote, that it never would have gotten the 2/3 majority in the Senate. So
Okay, were the same people, the same representatives and senators that voted for the 13th, were those the same ones that were not allowed to vote for the 14th, or was there an election in between there? Do you know?
now, I don't know exactly if there were. Of course, we have what 3 years between 1865 to 1868. We have 3 years between it,
Yep.
and the Senate, of course, is on a 2-year cycle. You know, every 6 years, but 1/3, and so forth.
Right.
So I think there was an election between the time that occurred. But the real issue, I think, you talked about how closely to follow the Constitution. Let me cite to you Article 5 of the original Constitution. Now, not the amendment, but Article 5 talks about how we propose amendments. And one of the things that it says, the very last clause of Article 5, it's really just one paragraph long. Well, I guess, let me just go ahead and read the entire thing. Whenever 2/3 of both houses shall deem it necessary, Congress shall propose amendments to the Constitution. Or they can call a convention for proposing amendments. That's kind of a hot button topic today about whether we should call a convention. I personally don't think that's going to be useful, but maybe another program for another day.
Right.
But then it says it must go on to conventions, be ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, provided that no amendment shall be made prior to the year 1808 in any manner affecting the first. It's basically saying you can't deal with the slavery issue.
Right.
But the very last clause, that no state without its consent shall be deprived of its equal suffrage in the Senate. So the question is, did the southern states consent to not have their senators not take a seat? They did not. The way that this was addressed is that they claimed the right to expel or exclude members, and of course, each house does have the right to exclude some members or determine the qualifications of the people in its house. But I believe that it was it was an ambush. I mean, it was planned from the beginning. The idea, there are actually some documents that have been preserved, letters and so forth, that indicate that they do not think the southern states will fall in line the way they're supposed to without the 14th Amendment. So as a result, we have to have the 14th Amendment ratified. So there were tricks played in the United States House of Representatives with regard to the counting, who actually had a seat and who was counted. The same in the Senate. And then when that happened, they claimed it was properly proposed and sent to the states. Then there was all kinds of problems with regard to the ratification of the states, which I know you'll want to probably take some time to talk about later. But some states ratified it, and then they said, "No, wait, we don't want to." Yep. Other states said, "We don't want to," and then they wanted to. And some states have, in this century, have taken steps to try to ratify it.
Absolutely. And I'm glad you mentioned that. A couple things here. Number one, they didn't let them, the people that had, and I'm not sure if they're the same ones that voted on the 13th or not, but all the same, they would not allow those people. And it was not just the southern states that they didn't seat. There was a senator from New Jersey who they knew did not support it. They didn't seat him. He had voted in support of the 13th, and he'd already been in, but then they're like, no, we're not going to seat you. We're going to unseat you, although we've already seated you. We're going to unseat you.
Right.
And the other thing is, as I understand it, in the southern states, amendments have to be ratified by states. So to me, that would tell you that you could not tell the southern states, or any other state for that matter, you can't get back in the union unless you ratify this. But don't you have to be a state to ratify? Territories don't ratify anything.
That's exactly right.
Yeah.
I guess the wording that I use for it is duress.
Coercion?
It's coercion. That's right. If it was ratified, and I don't believe it was properly, then it was ratified under duress. But the idea is that if you want back in the union, remember now, this is the same union that said you can't leave the union, you can't secede.
Right.
But if you want back in, if you want to come back in, then you have to adopt or ratify the 14th Amendment. So
Yeah.
I mean, a boatload of problems. I mean, the president even said it wasn't properly ratified. President Johnson at the time, Andrew Johnson,
Yeah.
said it wasn't ratified.
And I think there was another high-ranking official who, and I don't know if it was the Secretary of State or who it was,
The Secretary of State, yes.
also made the comment, hey guys, this is obviously not verbatim. Look, you can't do this. This is not legit. But they did it anyway because guess what? They had the numbers.
They had the numbers. Well, and
the guns.
And of course, they had the military.
Yeah.
They had everything on their side.
Right.
It was Sewell, I believe, the Secretary of State.
Yep.
Who basically said, was this ratified? And his position was, well, again, I'm paraphrasing as well. I probably have something in my papers here to quote him, but a paraphrase will do fine to save time. But essentially said, I'm not able to say that it is, but I'm not going to say that it's not. So let's just put it on the books and let Congress deal with it.
You mentioned that some didn't do it until the 19th. I know for a fact Kentucky did not ratify it. Now, Kentucky was never officially left the Union, although they provided plenty of troops to the Confederacy. They didn't ratify it till 1976. Mississippi, I'm trying to remember when Mississippi finally did it. Ohio initially ratified, and then they got a new legislature who said, no, we're undoing this. And then sometime in maybe it was 2003, it was sometime after the year 2000, they decided, hey, we need to go back and we need to ratify the 14th Amendment. So number one, I consider the 14th the fraudulent amendment because it's fraudulent in the way it was passed. And of course, I think it's even more fraudulent in the way it's put into, the way it's utilized today. But we'll get into more of that later.
Hey, one of the things about the votes that I think is interesting as well, because what you find is that the official version is that it was ratified properly. We have to get enough of the states. There were 37 states at the time. So if only 10 did not ratify, we don't get that. We don't get there. So what they did, they said if a state didn't ratify it but then changed their mind and did, we'll count that as a yes. And if a state did say yes at first and then changed their mind to say no, we're going to count that as a yes. So it's any way you get a yes, it counts. So that shows the problem too.
And there was the situation with West Virginia and Nevada, because both of those were admitted. And I'm not as familiar with the details on Nevada, but apparently that was there was something shady going on there about its admittance to the Union. And I'm not really, like I said, I don't know a whole lot about it, but West Virginia, now I'm from West Virginia. That's where my family's from.
Yeah.
It's an illegal state. Bottom line, it's illegal. It was created illegally, cut and dried. The Constitution says you can't form a state out of another state without permission of that state and then the Congress. Well, Lincoln knew that, and people tried during that time when it became a state in June 20th, 1863. People tried to tell him, hey, look, this is not legit. And what did he do? He supported secession because he thought he might need some more electoral votes in the upcoming election. So, you have that issue as well.
Hey, I don't know if you're interested. Actually, I said I could maybe find it. I did find the quote from Seward. It was William H. Seward, Secretary of State, July 20th, 1868, issued a proclamation that listed the official results. His tally showed 23 states that voluntarily ratified, 6 states that ratified under martial rule, really martial law, but martial rule, and 2 states that voluntarily reversed their ratification. Seward said in his official proclamation he was not authorized as Secretary of State, quote, here's the quote, I'm not authorized to determine and decide doubtful questions as to the authenticity of the organization of state legislatures or as to the power of any state legislature to recall a previous act or resolution of ratification. He said that the amendment was valid if the resolutions of the legislatures of Ohio and New Jersey counted, notwithstanding the subsequent resolutions of those states that withdrew. And he called into question the ratification of states which were under martial rule. So it sounds like he was trying to call balls and strikes the right way.
Right.
He just refused to put down his foot, and his equivocation opened the door for it to happen.
Yeah.
So, unfortunately.
But since the radical Republicans controlled everything and the military was running things, that it was allowed to stand.
Right. That's right.
So, what was the Supreme Court's understanding of the amendment for nearly the first 60 years after it was passed?
Well, yes, we don't have a lot of litigation under the 14th Amendment in that time period. We have an enormous amount that takes place starting in the 1920s, 30s, 40s, and so forth. But originally, it was understood that it was an amendment that, by its very terms, it binds the states. If it was properly ratified, then the states are bound to not deprive anyone of equal protection of the law or due process of law,
Right.
and not to deny privileges and immunities of federal citizenship.
Right.
So, if properly ratified, those states are bound by that. But there wasn't a whole lot that was going on with that. What made it really, I guess, catch fire is the concept of an incorporation doctrine. And I think you mentioned you want to talk about that tonight.
Yeah.
You want to go there now, or
Not just yet. So
Okay.
there was a major case within a few years, and there were some other lesser known cases, I think, before then, but I can't remember what they were necessarily about. But the slaughterhouse case
right?
in Louisiana, or out of Louisiana, and where somebody, because during the passage of the 14th Amendment, some of the proponents of it, to include, I think, one of the authors of it, at different times had made reference to the Bill of Rights, and this would this would make the Bill of Rights, this would allow the federal government to hold the states liable for the Bill of Rights, which
Yes.
the Bill of Rights were originally created as restrictions only on the federal government. I mean, even John Marshall admitted that, and that was the understanding for all this time, and really until we get to the 20th century. And so somebody did bring it up in the slaughterhouse case, and the court said, "Hey, look, the Bill of Rights applies to the states. The 14th Amendment did not change that."
Right.
That's another thing. Let's talk just a little bit about due process and equal protection. The due process and equal protection in the 14th Amendment was not a new standard of equal protection or due process, and because right now, well, in some cases have different, even today, standards of due process across the state? I mean, is every state identical? It's not identical. And I would imagine the same would apply to equal protection. Now, I understand they always sue and take this to federal court and get everything kind of off track, but as I understood it when it was first passed, the due process and equal protection meant whatever your state already had. It wasn't a federal standard. It wasn't, okay, the court will now decide what the federal standard is for the due process clause. It just meant whatever due process you had for the white man, you had to have for the black man. And whatever whatever penalty there was for the white man, there had to be for the black man. You couldn't punish the black man more. You couldn't cheat him on his due process. That's my understanding of due process and equal protection at the time.
Right.
And
That's exactly right. But you mentioned about due process. Here's one of the things that just absolutely blows my mind when you say something is short and then you call it's a tall short, or something's heavy, but it's a light heavy. Due process, the word is process.
Right.
And so originally the idea, what is process? In law school, and if you go to court, you have these rules of evidence, but then you have rules of civil procedure, or federal Tennessee rules of civil procedure, federal rules of civil procedure. What is process? It's procedure. And that's not the substantive law at all. This is how you get your day in court.
Right.
Process is exactly how it was ratified. That's what it meant. Your process can't be improper.
Right.
It's got to be fair. Of course, equal protection goes to equality there, but due process allowed the state to establish its own process, just like you said. Each state can set up its own process. and it cannot discriminate in the process. So, for example, if we're going to say that if someone gets a lawsuit filed against them, and the white folks, get 30 days to answer, but the black folks only get 3 days, well, then your process isn't fair.
Right.
Or, for example, you can be found guilty without even being notified that you were sued or being summoned to court. The, the concept is the process that you're due. Today, an entirely invented doctrine
Right.
by the federal courts called substantive due process.
Yep.
It's like saying it's process, but then it's not process. It's the substantive law. This is how they've been able to reach and gain all kinds of jurisdiction, claimed jurisdiction in all these topics, because they say the substantive law has to also meet their standard of due or fair. And they're trying to impose a federal standard. And it's my contention, and I believe the original intent and the documents at the time will show they were attempting only on the due process clause, attempting only to address the concept of the procedure
Right.
by which someone is made liable to the government. States could not have unfair procedure.
Right.
But if they wanted to have laws, today, like we have the transgender movement, we have equal rights amendment, we have all these things that try to bring in this due process and equal protection. And states, prior to this idea of redefining process and redefining equal protection and using the incorporation doctrine, states could make whatever laws to discriminate that they wanted to.
Yeah. But they had to discriminate equally. They couldn't discriminate against one race more than they did the other. And
That's right.
if you only had this much protection for whites, then that's the amount of protection you had for blacks, and vice
That's
versa.
right.
So that was
That's
the
it.
whole intent as far as the due process and equal protection clause of the 14th Amendment. And I mentioned the Slaughterhouse case. I think there may have been a few others, but that was the main one. And that was 1873. That was like 5 years after.
Right.
And I'm not saying that there weren't judges that dissented, but for the next almost 60 years, that was the understanding. And not only the understanding of due process and of equal protection, and that the 14th was a Civil War amendment, which means it applied to that situation and making sure that blacks weren't discriminated against, but something that made it even worse. When you combine the 14th Amendment due process and the equal protection clause, and then the court, you mentioned they created substantive due process,
Right.
which I don't think that's anywhere in the Constitution. Can you tell me what clause that would be in?
Yeah, no, it's not, and it's an oxymoron,
Right.
because substantive law is the opposite of procedural law, but it's substantive due process, so it's piggybacking one thing that's the opposite with another. So
it's kind of like make it up due process.
yes, that's right.
It's the federal court's ability to make it up due process.
Make it up.
Whatever
That's right.
they want, whatever they want it to be is the substance.
I think there's no better way to say it than that they essentially gave themselves a blank check. Whenever we decide in our wisdom that this is something that we think is unfair or we think is improper, then we have the authority to say that it's a violation of due process or substantive due process or equal protection. Take your pick.
Right.
We've got all three of these things at our disposal, and we can just pick the one we want when we want to pick it and give the result that we want to impose.
Before we get to incorporation, I kind of want to set it up here. So, like I say, some of the people who were involved with the 14th Amendment had at times mentioned making the Bill of Rights now applicable to the states, meaning that the federal government would enforce that. But number one, that's not what they finally wrote. Number two, that's not the understanding of any states that ratified it, because I would say even at that time, I don't think any northern state, maybe one of the extreme Yankee states, maybe, would have voted to give the federal government, especially the courts, because remember too, they were not very happy with the court. And in Section 5 of the 14th Amendment, it specifically says Congress shall have the power to enforce by appropriate legislation the provisions of this article. The whole citizenship thing had to do with the Dred Scott decision, just in 1857. So they were not all trusting in the court by any means when they wrote this. and they weren't wanting to defer to them. But in any event, it was never understood as applying the Bill of Rights, the first eight of the 10 amendments that are known as our Bill of Rights, to the states. If anything, all it did in reference to the Bill of Rights and the newly freed slaves, it made them equal citizens, because that would also mean that the federal government that they were limited from violating those rights in the Bill of Rights. They couldn't violate those amendments in reference to the newly freed slave. So that's how it made them equal. It wasn't, okay, now we are going to determine what these Bill of Rights mean, and we're going to beat the states over the head with it. And you know what really irritates me is, and I know you've read it, I know certain people, a lot of the people that listen to this have read it. We know the Bill of Rights was created because of fear of the federal government. They were concerned about federal overreach, and it was a compromise because the anti-federalists kept pointing it out, saying, hey guys, we don't trust this Constitution, doesn't even have a Bill of Rights. And some of them may have been sincere about that. Some of them didn't want to vote for it either way. Whatever the case, we got the Bill of Rights as a restriction on the federal government, not on the state government. In fact, Madison tried to get a version of the First Amendment applied to the states, and he was shot down. He's like, no, not happening. So that's what really irritates me, is when you incorporate the Bill of Rights against the states, you turn it on its head, in my opinion.
That's right.
Yeah.
That's right. And you can't do that. And I don't know. This is one of the things I'm asked to speak on this topic sometimes. I've got. I found my staff found this for me. This slideshow presentation I did, the incorporation doctrine.
Yep.
That has all the case law and so forth that shows what they did and how they did it. But the idea of taking the Bill of Rights, which was, as you said, designed to protect the citizen, first off, the citizen, the individual, and the state against federal overreach,
yep.
And then to give the federal government control of those rights, to control the states and the citizens within the states, turns it on its head. And let me do a little shout out here for a good pocket constitution. There's a lot of good ones, but I like this one particularly, the Citizen Rulebook.
Okay.
And the Citizen Rulebook, here's a good way to determine if you've got a really good publisher. Do they include, between the Constitution and the amendments, do they include the preamble to the Bill of Rights?
Yep, that's a good one.
That's a really good test. And so, in my school days, I guess they don't do it anymore, but we had to memorize the preamble to the Constitution, we the people
right.
of the United States, in order to form, that kind of.
If I remember correctly, that's fairly short. Can you want to read that, the preamble to the Bill of Rights?
Yeah, there's a preamble to the Bill of Rights, and so it's amazing that what the courts have done. They've completely ignored this preamble. So here it looks like it's about maybe 9 or 10 lines long. It says, the convention of a number of the states having, at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. Now, what are they saying? We're concerned about misconstruction, a fancy way of saying misinterpretation.
Right.
We're concerned about abuse of the powers that were given. So we want to add declaratory and restrictive clauses. They didn't say we want to give more authority. We want to give more power.
Right.
We want to be sure that we're pulling it back. And so it says that further declaratory and restrictive clauses should be added, and that is extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. So the main emphasis of the preamble, the states would not have adopted this Constitution if they weren't assured we're going to try for a Bill of Rights.
Yep.
They proposed 12.
Right.
They proposed 12. 10 were ratified. But each one of those is for the purpose of making it clear that there's not to be any misconstruction or abuse of the federal government powers. So when it says in the First Amendment, for example, Congress shall make no law
Right.
respecting the establishment of religion, it doesn't mean states, it means Congress.
Yeah. Doesn't mean your school board.
That's right. It doesn't say, it doesn't mean you can't put in God we trust in the motto, or, one nation under God in the pledge, or anything like that. But that's what they've done. So again, they turned it completely on its head. So look for that preamble in any pocket constitution. That's critical.
Who printed that?
This one is Whitten Printers in Phoenix, Arizona.
What organization put it out? Was that contracted by an organization? I can't see.
I think Whitten actually just done this for a long time.
Oh, okay, great.
And let me tell you, it's called if you're I don't know if you're not familiar with it or not, but this has such good stuff in it. It's got the jury handbook. It tells about jury nullification. It states the history, which is well established, the concept of jury nullification. Talks about when you're going on jury duty, what to do, and how to be prepared for jury duty. It's even got it here on page 8. It's got some people may have problems with this, but on page 8, it's got at the top a summary of the 10 Commandments, and at the bottom a summary of the Communist Manifesto. And I'll tell you, when you read the planks of the Communist Manifesto, we're at about 7.5 to 9.5, depending on how you do it.
Yeah,
how you
easily.
This is an excellent pocket constitution. So if you don't know about that, you can see this is an old one. I don't know if they're still printing them or not, but I really like it.
What was the name of the printer again?
Whitten, Whitten, Whitten Printers.
Oh, okay.
In Phoenix, Arizona.
Okay, yeah, I'll check that out.
Yeah.
Cool.
But it's got a lot of really good stuff in here particularly about the rights of jurors and what questions they can ask, and what are your inalienable rights that government cannot interfere with, and so forth. It's got some really good stuff.
Another thing too in the 14th Amendment, like I said, if you read the Civil Rights Act of 1866 and you read the 14th, you see the similarity, and that's what it was taken from. But it really refers more back to Article 4 when it talks about privileges and immunities. And those were the type of things they were, because my guess is that generation understood, okay, once they become citizens, well, that means that the Bill of Rights protecting the newly freed slaves, protecting them from federal overreach, well, that'll apply to them as well as it applies to us. Right. That's all that should have meant. And that's the way it was understood for years. So about 60 years after the amendment was passed, the first case was a First Amendment case. Gibbons, I'm sure you're more familiar with it than I am, versus Ogden or something like that. It was the first time
that we actually get incorporation.
Yeah, this is incorporation.
It finally appears in Gitlow versus New York in 1925.
Okay, Gitlow. Okay, an incorporation is a court-created doctrine. It's created wholly out of it's out. They just created it.
Right. They just made it up. Like you said, it was a First Amendment case. I've got a little summary here if you want me to.
Sure.
To talk about it. What I've said, I'm just reading from my slideshow here, my PowerPoint. Right. Incorporation finally appears in the case Gitlow versus New York, 1925, in which the court expressly held that states were bound to observe First Amendment free speech protections. Now remember, First Amendment, Congress can't make a law about religion, either establishing one or prohibiting free exercise. Right. Also, Congress can't. The federal government cannot do anything about free speech, but states could.
Right.
And it's a situation in this particular case in which someone went to federal court and said the state of New York has infringed upon my right of free speech, and what the court could have just said was no federal jurisdiction. Let the New York courts settle that issue, but that would not accumulate power in the way that you want it to be accumulated. They used incorporation that first time for the First Amendment for free speech.
Do you know how much pushback they got on that? I mean, you have any ideas or any record on people being outraged by it, or people thinking it was a good idea, or are they just there's the court? or what?
Well, uh, let me say first of all, the public in those days did not have access to information the way that we do. In 1925,
Right.
if their local paper would have maybe run something on it, they may have read. But as you can imagine, see, this is one of the reasons I think that this has occurred the way that it has. The courts have done this, and it really affects the parties to the case. It establishes precedent. But until we get mass media, until we get television and these types of things in which now all the nation's getting the same information.
Right.
In 1925, the parties would have known, and I guess it would have gotten around New York, of course. But
Right.
I'd say us folks down here in Tennessee never even read it or cared, unless maybe you were just a First Amendment attorney or something down here. But that's the idea. So it was, by the way, for my slideshow again, it was Representative John Bingham, the principal framer of the 14th Amendment, that advocated that the 14th should apply the first 8 amendments of the Bill of Rights to the states. So Representative John Bingham
Right.
advocated, of course, it's impossible to apply the 9th and 10th against the states because that's to protect the states and the people. But anyway.
Right. I'm sure they would try it.
Yeah,
but now
the court declined to do it, though. I mean, that was his suggestion.
Yeah.
So get low is where it comes about, and then a really big case is Adamson versus California that we get to in 1947. That's kind of really popularizes this concept. So see, it's incrementalism.
Right.
You take one case and you say, okay, let's incorporate. If you don't have free speech, then that's not due process. So we're going to take due process and we're going to say it's incorporated against the states. Originally, yes, Congress could infringe on free speech, but now states can't. And we're going to say how and when they can infringe. And now we have one national standard. That was the idea.
Right.
Small little things, and then they have another case, and then another case, and another case, and then of course we get to mass media. And I guess in my memory, the thing that really caused, I think, American public to grow concerned is we got to the 1960s, and we get the use of this incorporation doctrine with regard to the religion clauses.
Right. Right.
Madeleine Murray O'Hair, tries to take a prayer and Bible reading out of the schools, and the Supreme Court buys that argument. They take the bait, and they use the previously established things. And now the people of the United States begin to get outraged. How can this happen? And see, they were asleep at the wheel for 35 years. It began in 1925.
Yeah. Well, and then I call it the cult of the court. Everybody thinks somehow
Right.
that, our founding generation, they sacrificed all that so that your freedoms in the future, that of
Right.
your children and your descendants, could be decided by 5-4 Supreme Court decisions.
Right.
That was really worth all the suffering, right?
That's right.
I mean, that's insane, but that's what we believe, and that's what we pretty much say every day. And the Mark Pulliam types will swear by that, and you know exactly who I'm talking about. But most of the people accept that hey,
Right.
it goes to the court. And to me, that, I've always heard we're a nation of laws, not of men. Well, I'm sorry, if we're allowing, number one, the court to do something that it does not have the constitutional power to do,
Right.
then no, we're not a nation of laws. We're just allowing a certain branch of the government to do whatever it wants.
Well, yeah, that's correct. And I guess I've talked about incrementalism. This is kind of how it comes about. The interesting thing is that we have this in Get Low 1925. Then this Adamson case comes along, Adamson versus California, 1947. And what's interesting about it is that it's the dissent, one of the dissenting justices, Hugo Black, is the one who really makes this argument. Hey, this is what Representative Bingham really wanted to do back in the day. This is the thing, we really should reflect on this and consider this again. So the dissent in the 1947 Adamson case is what provides the intellectual fodder for the next cases and the next people to say, oh, let's try to use Justice Black's theories and his strategies.
Right.
And then it snowballs.
So, okay, yes, Bingham said that, but he also said contradictory things.
Right, he did. That's right.
And it doesn't matter so much. I can sit here and read something and tell you this is what I want, but if this is not if what I say I want and what I put on paper and what the people of the states ratify is not what I said I want, well, then guess what? That's not the law. That's not what passed. You have to put it in the language people can understand, not privileges and immunities and due process and equal protection equals the federal government will now use the Bill of Rights against the states and beat them over the head with it.
Yeah.
But that's what they've done.
Well, right. And see, I guess you've hit on a very important thing. We can always go back and look at the debates and so forth, and things were ratified or proposed. And to think that when something was actually, when the final language of the 14th Amendment was purportedly ratified by the House and the Senate and then sent to the states for ratification, the idea that they spoke with all one voice, they all had the same idea, they were all unanimous, we know that's not true. Even today, something may pass by the slimmest of margins in a Republican-led House, and there's a few votes that probably got strong-armed into that, and they didn't care for that at all, and
Right.
that they're, party loyalty, and so this idea that what Bingham says is what everybody thought, he's speaking for himself.
Right.
That's it.
Yeah.
And there's a principle of constitutional construction or interpretation that's very important, I think, for us to consider as well. And that is the legislative history is not relevant unless there is clear ambiguity in the language. If the language isn't clear, then it gives us a license to go back and say, what did they say? What arguments did they make? How many on this side? How many on that side? When the language is clear, particularly on amendments that are sent to the states, so Representative Bingham down in the United States in Washington, D.C., proposing this, how's a citizen of Georgia, supposed to know what Bingham said or what he meant? They're looking at the language.
Right.
The state looked at the actual language. They had their own debates. If they wished for guidance, they could get some, but it's not what someone intended. It's the actual language. And so you make an excellent point about that. And a lot of people have fallen for that. I know we're not talking about the First Amendment unless we're going to talk about it being incorporated, but that's exactly what's happened with the First Amendment. You've got Thomas Jefferson, in a presidential letter who uses the phrase
Separation of church and state. Yeah.
State, and now it becomes a doctrine as if that's what everybody thought and what everybody meant. And it was no such thing. The same thing's been done to Bingham and a few others that advocated for really coming down strong and hard on the states. And so it's just their opinion, but it's not the text.
So let me ask you this.
Exactly right.
When would you look, because I happen to think, and obviously I'm not a lawyer, never will be one, but I happen to think that the legislative intent has to be looked at least in some cases. So when would you look at legislative intent versus just the language? I'm just curious.
Yeah, the prevailing doctrine. You can question whether you like this doctrine or not. The prevailing doctrine is, if the text is clear on its face, it doesn't matter about legislative intent. Okay? Ambiguity is the question. So if we're not sure what was meant by that word, then we can go to legislative history and decide. But if we're sure what the word means, then that's what it means.
Okay.
That's the prevailing doctrine in courts today. That you have to provide, some ambiguity, something not being clear. Then we'll consider that. I mean, you can argue legislative intent anytime you want to, but courts if they're following their own rules, they're not supposed to be swayed by that argument. So,
I can kind of see both on that, but I do know this: if you're going to say that, even if you're going to use the legislative intent, Bingham's claim of, hey, this is what we meant, his language in the bill in no way, shape, or form matches up with that.
That's right. See, therein lies the reason, I guess, for the doctrine. Again, it's a court-created doctrine. Rules of construction and interpretation are just created by the courts. There's no constitution that says that, and there's no constitutional rule book that's
Right.
ratified by the citizens or anything like that. So they try to give the Supreme Court has been very active in creating all these rules and doctrines. In fact, it's almost, oh
It's a separate constitution almost.
yeah, that's right. Virtually, okay. First Amendment religion clauses. They've created things like strict scrutiny.
Yeah.
Well, so in this particular case, it's strict scrutiny. In this particular case, it's ordinary or simple scrutiny. Uh, they create these things just by the court to try to give themselves, I guess, guardrails. But then the thing is, they just remove the guardrails whenever they want to.
Well, it's
And
funny
so,
you said that the general rule is they go by the language and they're not going to make a reference to the legislative intent. But then they make up their own rules. They make up their own language of strict scrutiny, or what is it, intermediate scrutiny, and whatever,
right.
whatever we feel like scrutiny. They make that up, and that's okay. And
Right.
for instance, I'll tell you another one that really irritates me is the whole, I think, the Miller test on obscenity and pornography.
Yeah, that's right.
So, that just blows my mind that we allow that. I don't understand why the states play along with that, because the states should be able to decide for themselves. Hey, this is obscene and we're not going to allow it in the school. We're not going to allow it in the library, or we're not going to allow it wherever. That should be a state prerogative. And oh, by the way, First Amendment says Congress. So how is it that they get? That's the thing too. If you're going to take the First Amendment and incorporate it, I would think you would have to have something in the 14th Amendment that says that scrutiny is no longer limited to Congress, passing a law that restricts or promotes religion. I would think they would have to address that, but they don't.
Well, in the incorporation doctrine presentation, one of the issues that I bring up is that at the time that the 14th Amendment was ratified, states, again, remember 1868, we don't have mass media. Not everyone's aware of what's happening, but they're aware that their state legislatures are dealing with this concept of the 14th Amendment. We've got to do something about it, right? So the general public, I think, has some idea. They had no idea, no clue, of course, that someone's going to come around years later and say we're going to use the wording of this amendment to stranglehold this state with regard to things like you said, pornography or obscenity. The 14th Amendment's been used. It's how they got to abortion. It's how they got to all the religious cases. Stone, the Stone case in 1980 on the Ten Commandments. No Ten Commandments in schools. Just a whole wide variety of things. The 14th Amendment provides the basis to get to that. The public would have had no idea about that. It's been incrementally done.
Yep.
And by virtue of that, I believe it's time that someone expose. Now, you keep asking, it's a good question. Why do states tolerate this? It's this idea. We could probably do a whole show on this one too. But the misunderstanding of the supremacy clause.
Right.
Most of the states and lawyers go to law school and they say, "Oh, I don't think the federal government should be able to do that." I don't understand the 14th Amendment that way. What do you mean? The Bill of Rights is applied against the states so that now the states can't do the things that we were designed to be protected from the federal government for. How is this? Oh, supremacy clause. Oh, so the U.S. Supreme Court said that? Yes. I guess that settles it.
Yeah. It's that cult of the court. And,
Yes.
and 99% of the lawyers have it, and 100% of the judges, from what I can tell. And
Right.
even though, like, Thomas and Alito are the two best up there, they still buy into that.
They do.
They do.
That's right.
Now, Thomas, on this recent, in the Dobbs case, I believe it was the Dobbs case, made comments about, hey, the whole substantive due process issue.
He did.
And he said that, we might have to, he said, we're not doing it now, but we might have to relook the marriage case and this, that, and the other. And he's absolutely right. And I've been disappointed they haven't done it.
Right.
Because think about it, and think about how long have they been using substantive due process to strike things down or say, well, you now have this new right, this new group, this newly created group who decided that they are X, Y, or Z now has this new right. It's irritating and frustrating. And, I know a lot of people will say, well, hey, sometimes we win in the Supreme Court. Well, I like the Bruin opinion, okay? I like the Bruin opinion because I'm a Second Amendment guy. I'm also a Section 26 guy. And I'm well aware that our state violates our state constitution.
That's right.
And pretty much every other state violates their state constitution. And so a lot of people are happy, with the Bruin opinion. I'm happy with it, but you know what? That's still an abuse of the incorporation.
I think what you're saying is sometimes we get the right result, we just get it in the wrong way.
Absolutely. Because anything that empowers the federal government, just because you like the way it turned out, that doesn't mean that it's good overall, because you're saying, well, hey, we're gonna bow to the federal government here on something, another right and another power they've usurped, but we're okay with it because we like the way it turned out for certain things. So we have to be consistent, in our worldview and in our jurisprudence, and so sometimes, like for example, there's some things that Donald Trump does that I really like, but candidly, he doesn't have the authority. Oh, absolutely.
So we have to be willing to say, if we're going to be purist, and I try to be, and some people laugh or criticize because I'm an ideologue, but I think ideas are the things we need to focus on. So I'm an ideologue, and we need to go back to do it the right way. Do it by the book. Yeah. If we don't like it, then change it. If we're going to change it, make sure that we say what we've changed.
Right.
And by the way, one of the things that you had up on the screen earlier, I think is one of the critical things when it comes to the 14th Amendment and how it's utilized in the incorporation doctrine, and that's Section 5. In my presentations on the 14th Amendment, there we go, great. So the question is, who has the power to enforce the provisions of this article? Congress does.
Congress.
Where does it say the courts have the power to enforce anything? Not only are the courts enforcing it, they're rewriting it.
Yep.
So all that the Section 5, I think, does authorize Congress to enforce it, but they enforce it what? Against the states. See, that's the whole purpose. The 14th Amendment was to regulate the states. And so what would legislation look like? Well, it's my idea that legislation would look something like this. If Congress believed that Tennessee did something that was contrary to the 14th Amendment, then the Congress, the House, should propose some legislation.
Right.
The Senate should ratify it. It goes to the president, and it says Tennessee can't do this. They're in, and so here's what we're going to write some legislation to impose some kind of penalty or something on Tennessee for a violation of the 14th Amendment, but it's not nationwide.
Right.
You need to enforce this against the states that violate it, and I suggest that the courts don't have the authority to address this without federal legislation.
Yeah.
There has been some, of course. We have the 1960 Civil Rights Acts and so forth, in which they would say that that's an attempt to enforce the 14th Amendment. So that would then give the federal courts jurisdiction, hear the case, but they just wander afield. The federal courts just wander afield and pick whatever topic they want and pull it in and say we're gonna enforce this. Yeah. So
you mentioned, they may have in the 60s they gave the court jurisdiction to do it. That's another thing. I always hear, well, we got 3 equal branches. No, we got 3 separate branches. Congress is supposed to be the most powerful branch. Right. And and I know you know this, reading the Constitution when it gets to Article 3 and talks about the judiciary, they have original jurisdiction according to the Constitution. So Congress cannot mess with their original jurisdiction.
That's right.
But they can regulate to their heart's desire their appellate jurisdiction.
That's
they
correct.
They could say, you know what, we got too many federal courts. We're going to do away with all of them. Hey, Supreme Court, you want to be supreme? You are now supreme. You're going to handle any and every case. Oh, and by the way, you're going to handle them. You're not going to defer them, because they could tell the court, if they wanted to, they could tell the Supreme Court, you cannot defer a case. Or they could set a whole class of cases and say, you cannot hear. They did that after 9/11, whether it turned out good, bad, or ugly. They did that after 9/11. They did it on prison reform in the 90s. They've done it off and on. They have the authority to do that, but they would much rather hide behind, well, it's the Supreme Court and we can't do anything about it.
Right. Yeah. The exceptions clause, Article 3, Section 2, talks about Section 2 of Article 3 is the part of the U.S. Constitution that addresses the courts, the judiciary.
Right.
And then Section 2 specifically talks about judicial power,
right.
what it extends to. And so, like you said, some things, a very short list, does the federal court, the Supreme Court, have original jurisdiction.
Yep.
But then it's the second paragraph of Section 2, Article 3, Section 2, Paragraph 2, talks about in cases in which they have, it says that they've got original jurisdiction in cases affecting ambassadors, other public ministers and consuls, those in which a state shall be a party. The Supreme Court shall have original jurisdiction, period. Next sentence. In all the other cases before mentioned, and the ones we're talking about up there, controversy between states, about lands, between citizens of different states and so forth. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and to fact. And here's the thing that you're mentioning, with such exceptions and under such regulations
yep.
as the Congress shall make.
Yep.
So Congress does have the right to pass a law to say, for example, and I've said this before, say people were really upset about the prayer or religion in schools issue. We can't sing Christmas carols at Christmas time anymore, whatever it may be. They have the right to say that is not going to the U.S. Supreme Court. Where would it be held? Remember, it's important to remember this. When the Constitution was formed, there were no federal district courts.
Yep.
1787, they created lower courts.
Right.
At the time the Constitution was ratified, where would they expect a case about religion or the First Amendment to be heard? They would expect that to be heard in their state courts.
Yep.
That was the whole plan. This idea that we have today is that state courts are not capable of deciding federal issues. They did from the beginning.
Yep.
What I say to people is, I know here in my county, in East Tennessee, Greene County, going back to 1960, if there was any state judge that took this case about taking prayer or Bible reading out of the schools, and if there was no appellate jurisdiction to the Supreme Court, and it had to stick in the state and before that judge, people here know where he lives.
Right.
People, they know where he goes to church if he goes to church, and they know where he shops. Yep. See, this is the type of thing that if it would have stayed on the state level, back to your point, why didn't the states do something sooner? Like this is happening in far off D.C. It's just, it's theoretical. This is the gray matter type of thing for people, and it's not coming home. And if this had been, if we would have made these things stay at the state level with their state courts and go through the state laws before appealing to the U.S. Supreme Court, it would be a far different thing. That exception, the exception of appellate jurisdiction is a very important thing.
Yeah. And I think, that I've never heard, I'm not aware of anybody in recent years that's proposed any legislation to limit the federal court, because I guarantee you, if they even brought that up, they would get all this pontificating about, well, the court, created by the Constitution, and we got three equal. No, I still contend we don't have equal branches. If you read, they are not equal. They were never intended to be equal. They're separate. But that's really, right. And just like Hamilton said, that's the weakest branch. Now, it's the weakest branch if you have a president with a spine, if you have a Congress with a spine and a brain. And, we certainly have a president with a spine. Unfortunately, when it comes to the court, he's almost spineless. I mean, it's funny here because I'm just going to say it. He violates the hell out of the Constitution when it comes to war powers.
Yes.
But then he allows the judiciary to just tell him how high to jump on the way up, and goes along with anything, no matter how patently unconstitutional it is. Because that's the deference to the court. That's the cult of the court that we've been pushing in our society for at least 100 years.
That's correct. That's correct. That's exactly what we've got. Well, it's the cult of the court, and it's also, I think, the cult of the federal government being supreme. Again, the perversion of the supremacy clause, which again is worthy of a whole 30-minute session sometimes. Because, you really wouldn't be able to get this incorporation doctrine, on going down the hill fast if we didn't combine it with a few of these other things. And all these working together have just created pretty much bow to the courts and do everything they say.
Yep. Yeah. And I mean, here's the thing. They've been unleashed really more in a lot of ways, even though we do have, I'm not going to say we have a conservative Supreme Court. We have a better Supreme Court now probably than we've had and certainly in my lifetime. And they've made some okay decisions, made some good decisions, but I mean, they've made some bad ones, but they're not turning the tide because as long as they're not going to be the ones that curtail federal power. If anything, they have given the feds more power. I mean, it's very rare that they strike down a federal law. And, it's funny though, even Justice Marshall, who was very rarely passed up an opportunity to take more power for the federal government, even he recognized that the Bill of Rights just applied to the states.
Oh, right, of course.
And so there's no debate about that prior to really 1925, almost 60 years after the 14th. But I don't see us. I don't see us fixing this country if we don't get, because the 14th Amendment has become the Constitution.
That's right.
It's pretty much replaced the Constitution.
Well, to your point, I've mentioned incrementalism, and even the ones that on the court, even going back to Scalia, when we had Scalia and Thomas, they would write about these things, and I don't support it. I don't think that it was right, but they've never gotten enough of their fellows to go along with anything. I think Thomas would probably lead the charge if he felt he had the votes, but of course I'm surmising here.
Right.
But I think he's trying to lay the intellectual foundation,
right?
Kind of like Kavanaugh did recently, in his dissent on the tariff issue.
Right.
He kind of wrote in the dissent and said, "Now, if you really want to do it, here's the way you do it." Of course, that doesn't mean that he'll still get 5 votes if they follow Kavanaugh's strategy. But the bowing to the courts. Let me just circle back to one of the things that you said, which I think almost no one understands, and it is one of the centerpieces of the Constitution course that I teach, particularly the 40-hour course. It's this myth that we have 3 co-equal branches of government, even this idea of checks and balances. And certainly there's some aspect of, anytime a governmental agency does something, it's a check on something. But clearly, the easy way to persuade someone that the branches are not co-equal is to ask the question, which is what I do in the course. I say, who has more power? The person that has the power to hire and fire, or the person who is being hired or fired? And of course, the answer to the question is the person with the ability to fire someone who's been hired has more power than the person that's being fired.
Yep.
So here we go. Congress has the power to fire the executive branch,
Yep.
the president, vice president, many of the cabinet members and so forth. They also, many people do not know, but there is impeachment power for the courts as well.
Yep.
So if the Congress were to do its job, if they were to say, going all the way back to these early cases, how can you say this? I mean, 1947 Everson, and then we talked about the 1947 case Adamson. 1947, we had a couple of really landmark cases in which they began to pervert these doctrines of the court. In Everson, it's where they came with separation of church and state. Congress could have just said, hang on, we're going to begin an impeachment proceeding here. You justices have done what? And could have removed them from office, or perhaps kept them in check by threatening to remove them from office, much like FDR did.
Yeah.
He
I would
put
be
the
happy
courts in-
just to see them use the power under the Constitution to say, hey, court, you know what, that last little thing you came up with, yeah, we're throwing that out, okay? Because, or it's going to be void from here on out because here's the law we're passing, and we're
Right.
restricting your appellate jurisdiction. So
That's right.
you won't be allowed to screw this up again.
There
Your
you go.
days are done. I'd love to see that. And I would love to see the court stripped almost bare.
Right.
The federal court's almost bare because guess what? Their original jurisdiction, I really can't see giving them much more than that.
I agree.
Yeah, and I understand that, what I always hear in the Pullman types, Mark Pulliam types will tell you that, well, it'd be chaos. Well, wait a minute. All the laws in the states are not the same now. Pick any topic. They're not all the same.
Well, I think you and I may agree on this. If we don't, that's okay. But I think that however you define it, I think chaos is better than what we have now.
Yeah, and you're right, because you know what? They are actually only okay with court created. If it's federal court created chaos, it's okay. If it's
Right.
federal supremacy created chaos, it's okay. But if it's a state looking out for the good of its people, are making the decisions that those people have empowered their leaders to make in their state, oh, we can't have that.
That's right.
Yeah. I'd much
Yeah,
rather take my chances.
Something's got to change, and quite frankly, I think each state pushing back is the best, fastest, and clearest way. And I think the Constitution's on their side as well. Constitution and certainly common law is on their side. So we need a little competition. We need a little chaos. That's kind of happened in some respects with regard to all the people that are going to be fleeing all these. It's yet to be seen what's going to happen with New York
Right.
City. All the people there. California's lost how many billionaires because of the egregious tax policies there.
Yep.
So this idea that states are not to be uniform, states are entitled to their own identity. They're entitled to select and try to draw the kind of citizens they want. Imagine how this would work if we didn't have this overarching umbrella of federal law with regard to labor, the
Yeah.
Department of Labor. It's unconstitutional. There's a Department of Labor has a place for interstate commerce,
Right.
but within the state, no jurisdiction. So what if states could say we're not going to follow these federal laws with regard to OSHA?
Right.
We'll do our own safety. Maybe take more risks. Maybe people here in Tennessee don't feel like they need to have this helmet on all the time. Maybe they feel like they don't need this injection, to be safe.
Yeah.
Let Tennessee decide. It's competition. I think it's the only way that we save ourselves because this mentality that we're uniform, we're marching straight to Marxism, communism, socialism. So.
And I know the problems in our country, I understand they have a moral and spiritual foundation as well.
Right.
But I cannot think of any public policy, any problem that has not been created by the federal government. I'm not saying states haven't added to it, okay?
Yes.
And I'm not saying states haven't done stupid things. But, fortunately, I don't have to abide by all the stupid things California does or New York does.
Right.
But all the problems that have been put on us by the federal government, by this idea, this acceptance of federal supremacy, this acceptance, this cult of the court, look at the problems it's created. We've got, we've got the Islamic invasion, we've got the illegal immigration, we've got the perversion that's pushed on us by the court. You name it, the gay marriage, the LGBT, the transgender garbage, all of these things all come from the federal government and are pushed on us.
That's right. And I think it's interesting. Those that want to push for uniformity, we can't have these divisions and so forth. Well, what would they say if we say, you like uniformity? Let's let Dave and Jeff decide what the rules are for the whole nation. You want uniformity? Oh, now they don't want uniformity anymore.
Right.
Yeah. So this is really it's a spiritual issue at its core, but it's a worldview issue. It's an attempt to deny mankind his right to exercise his God-given rights, to say no, I don't want to participate in this. You can't make me, and I want to live in a state that doesn't make me, and the federal government can't make me either.
Yep.
When you create that kind of environment in just one state, and see, this is one of the reasons they can't allow this to happen. I often say that these principles that we're espousing, I don't have to have in a 50 let's say a 50 student classroom in your local high school. We're going to discuss government or civics or whatever the case may be. I don't need 50 people to understand these principles. I just need one. If one person really understands these principles and they're given a platform,
Right.
it will change people's minds. It may not change everyone's minds. There are always
Right.
these do-gooders who, in the name of morality, their morality, want to impose upon the rest of us their perverseness.
Yeah.
But we just need a platform for this type of thing. So if even one state could create this, oh, what a firestorm this would do. It would truly, I think, revolutionize.
Oh, I agree. And something's going to have to revolutionize soon, because the way we're headed, like I say, our federal government allowed our country to be invaded by all these. They brought them here. They recruited them. They brought them here. And they really, yeah, we've closed down the border, but I'm not confident that we're going to get rid of all those people we brought over here. And I blame our government for the Muslim invasion in this country. That's who's responsible for it, not us. But they put us all at risk. They have put us all at risk. And it just irritates me to no end that we've allowed this.
And of course, we've got, I guess just recently in the news, I think this past week, Saturday, these no kings rally or whatever.
Yeah.
And for people to think that these are spontaneous, grassroots from the people, these people are bought and paid for. It's the money that's coming down from people that despise our country.
Yep.
Many of them out of the country, living out of the country,
Absolutely.
sending money back in to do it. There was a group over here in East Tennessee, by the way, that did a counter protest at these No Kings rallies, and I'm really, really happy with what they did. I've not gotten a report about how it turned out, but I read some of the press as they were trying to organize. They said, "Look, we're going to be peaceful. We're not trying to infringe on their right to say their stuff.
Right.
We have our right to say our stuff." And they said, "They're going to say no kings. Here's what we're going to say. We're going to say no kings, no queens, no chaos." So,
I bet they didn't like that.
I thought that was pretty good too.
I was thinking about this the other day, and this is an example of how the perversion by the court, the perversion of incorporation, in this case, the First Amendment. So they have now, in terms of anything having to do with religion, that is now a federal court decision, okay? And they tell you, because even back to the 1830s, and don't get me wrong, I'm not advocating for a state religion, okay? But
right.
Obviously, they had that even up into the 1830s in some states. They had it.
That's right.
In mid 1830s. I think the last couple of states got rid of it. But when we federalized the First Amendment, and now anything is having to touch on religion is a First Amendment issue, therefore ultimately a federal court opinion. Think about this Muslim invasion. If we said, you know what, we're no longer going to accept that the First Amendment has been incorporated, and we no longer had to worry what the federal government had to say about it or what the federal court had to say about it, you know what, we could say, hey, look, Islam is not a religion. It is a death cult from the bowels of hell, and you have no right to practice it in the state of Tennessee. We could ban whole groups, and that would be well within our right, unless it violated our state constitution, right?
That's right, yeah.
But as it is, we're going to have our hands tied behind our back trying to fight these people in the court.
Well, Texas, of course, is having a big issue with that, with the whole Sharia law cities and so forth. And Michigan's already got no-go zones for police because we're being taken over from within. And again, I agree with you. Our tax dollars subsidized it. How the tax dollars got to us might be something along the lines of we gave it to Ukraine. Ukraine turned around and gave it to some other people who then turned around and gave it back to us. It's our tax dollars that are bringing them here. supporting it, making it so. We're going to have to deal with this Sharia law stuff and these Muslim communities. I hope that people will wake up. Uh, you know, the call to prayer 5 times a day in New York City now, that should cause some New Yorkers to really wake up.
Absolutely.
Or what?
Absolutely. And you know what? If that were reversed, if they were ringing church bells 5 times a day, the
Right.
LCU would already have it at the Supreme Court.
That's right.
And hey, you know what? If you live in New York and you live in New York City, you were stupid enough to elect that guy.
Yeah.
You deserve what you get. Unfortunately, there's probably some decent people in your city that are also going to get what you brought on them.
Yeah. See, that's the disadvantage of this election thing. 51% going to control, who gets in the office, and the 49 that maybe didn't support him or whatever the case may be have to deal with it. But there are consequences, and so I'm an advocate again of, the people have a God-given right to create the kind of government they want. Just don't make me have to deal with it. And I've said before, where are the people that just want to be left alone? Is there going to be any place for the people that just want to be left alone?
Only if we make one.
Right.
Only if we make one.
That's it. That's right.
You mentioned classes. You teach different classes. You want to talk about that just a little bit?
Well, I mean, I can. People often ask me, when's the next class scheduled? And I'm not trying to be cute or coy when I say this, but I don't ever schedule the classes. About 25 years ago, I've lost track. I guess it was about 25 years ago. Someone knew that I had an interest in these things, and that I was talking to my representatives about legislation, and I'm kind of following this kind of stuff as kind of starting out as a hobby, so to speak. And they said, "Well, can we learn?" And so I began. Someone would say, "Well, what about this? Can we talk about this topic?" So I'd say, "Okay, sure," and we'll get a class together. And I guess it was maybe closer to 20 years ago that I began to do a 40-hour course called Institute on the Constitution. And what I actually did, there's an excellent organization. At least I think they're still around, but they were at the time. They did some set of DVDs. They had Colonel John Eidsmoe, who was he was a constitutional professor, actually served the Alabama Supreme Court, but he also taught constitutional law. He did it seems like it was 12 1-hour, 30-minute to 40-minute sessions.
Right.
And I got that, and I thought, those are really good. People need that. And so how are we going to let them watch it? They can just watch it in their homes or whatever. But I said, why don't we just have a class? And so I thought about the class, and I thought there's so much more we can do with that. Just more than the 30 minutes. We need to discuss some of these things. And so I kind of built around that Institute on the Constitution, which is their name.
Right.
And their DVD series and so forth. But they were pleased to allow me to supplement with a lot of my stuff. And so I've supplemented what was about a 30 to 40-minute DVD is now a 3-hour course. I've built about 2.5 hours more around the 30-minute. And then I've added one more session at the end. So it's 13 weeks.
Wow.
And so 40 hours. And we typically go one night a week, say a Tuesday night, and we'll go 3 hours on a Tuesday night for 13 weeks in a row, something like that.
Right.
And it covers everything. The thing about the course, you don't just start with the Constitution. In fact, it's only by lesson number 5 that we actually get to the Constitution.
Wow. Because
like I said, as we began this series today, you can't just analyze the Constitution in a vacuum.
Right.
We begin with the first session. We spend 3 hours talking about what is law and how do we know?
Right.
How do we know what law is? Is it just what the tyrant says? Is it just is it tribalism? Or is there, I use the concept, I tell people, you cannot study the Constitution or have a discussion about law until you base it in religion. So we have to start with this idea. Is there a higher law by which man's laws must be judged?
Yep.
Answer is, of course. If 51% of the people say we're going to take away all the property of the 49, then that's no law at all.
Right.
That's pure democracy.
Yeah.
So anyway, we go through, so what is law? And then we talk about the founding of the country and Columbus and his role. And Catholicism kind of started out in Mexico, Puritanism, the Church of England and so forth, kind of began the East Coast and looked at two different philosophies about government that came from those groups. That's kind of what it's about.
Okay.
And I don't ever charge for these courses. They're all free. So if someone wants to have one, I guess you asked to talk about it. I don't ever schedule them. Someone just says, hey, can we have a course? So for the 40-hour course, I've got a rule. I need at least 50 first timers. And if we get 50 first timers, then I'm happy to dedicate myself to the 40 hours and get through that. But I have a multitude of other courses about things.
Is this via Zoom? Is this via Zoom or is this only in person?
It's live. Yeah,
Oh.
we do them live.
Okay. Okay.
Yeah. So sometimes we've done them in churches. Sometimes we've done them in libraries. VFW halls. One group we did it at the I forget the name of the hotel, but we had a hotel room. I just did one of those in Newport in 2024. I did one in Newport at like a day's end or something like that.
Now, I know you've done, and I think I went to one or two of yours. There were like all day things, but that was not a complete course. That was like, I think,
Right.
a 5-hour or 6-hour deal. But what's your radius on these? I mean, I know you live in Greenville, so how far will you go out on these?
I've gone 500 and 600 miles for one day things.
Wow.
Yeah.
Wow.
In fact, in Pennsylvania, I think one of the ones that you saw me do is called I call it Foundations of the American Republic.
Yep.
It's 5 hours. We start with the kind of idea, what is government? What's the scope of government? We end up with the idea about the tension between states and federal. We talk about states' rights and
Right.
we show how the Constitution has been perverted against the states and against the people.
Yep.
But they asked me to come to Pennsylvania and do one of those. So I went to Pennsylvania, did a Foundations of the American Republic, used the Pennsylvania Constitution there to show them, what their rights would be.
Right.
I went out of state for 40-hour courses before also, but I can't do them weekly. So
Right.
someone out of state wants one, I can take a whole week and we'll say we're going to do our 40 hours and try to get,
Do you have a website?
no.
Okay. They just call your office, Cobble Law Firm?
They just call the office and say, here's what we're interested in doing. And they say, well, when are you thinking about doing it and where? And they'll ask, they ask me if I can afford to drive, for that. But, I don't think I've done a 40-hour course in the Nashville or Capital region. If we could find a way to make that happen, I would be delighted to do that.
Okay. I'll work on that.
A lot of people have said, why don't you do this by DVD or Zoom or whatever? And I understand the benefits of technology. I'm not against it. I'm kind of a little old fashioned, but I know technology. I'm not against it.
Right.
But I'm going to tell you, Dave, what my experience has been. My experience has been that when you do these live,
Right.
there is a vibe in the room. When people begin to understand, I give some
Right.
illustrations. I show how the Constitution was perverted. I give the expression. It's almost like a tent revival.
Right.
There's an energy that goes through the room like, what?
Yeah. Yeah.
How could this have happened? And so it's been my experience that I want to do more than just teach the information.
Right.
I want to change people's focus.
Right. Yeah.
And, so I hope people are watching tonight. And it's education. That's great. But the question is, how many people will actually unify? See, this gives me 50 people get to know each other.
Right.
They get to build bonds. They get to hear these questions and answers and so forth. And so I've got these people that maintain relationships for the rest of their lives because they met at one of these Institute of the Constitution course. I've just chosen just to do them live.
Well, the more people understand how it's been perverted and used against us, and the sooner, the better, because I don't think we have a whole lot of time left. Any closing thoughts from you?
Oh, my goodness. Just pray for our country. Pray and work for consistency, a consistent interpretation with regard to not only the scriptures. I mean, we have debates about what's the Bible mean too.
Right.
You've got to have your right principles of interpretation. It starts with that, and so without a foundation for proper interpretation, you'll be misled. And I guess one of the final things I would say, I don't want to go too soft on the legal community, but what I have found is that if we go too hard on judges or lawyers, we turn them away many times. There have been judges that have come to my course, judges that I appear before, have come to my courses, and other attorneys come. I wish more would come,
Right.
but
I do too.
I guess they don't know what they don't know.
Right.
And so, if we could encourage them to begin to experiment with some of these ideas, uh, hey, here's an idea: could we get a law school? Could we get a law school in Tennessee that says when you graduate, you're going to know all the nonsense that the Supreme Court's made up? We're not going to deprive you of that. You'll have to pass that on the bar exam. We're going to give you the other side too. Now, you tell me which one you think is consistent, which one is rational, which one is true fidelity to the Constitution. If we could begin to make inroads into the legal community, that's the key thing there, I believe. So I would hope that we could do that.
You set up Cobble Law University, and I'll make a donation. Unfortunately, I don't have deep pockets, but maybe I could find some that do.
Well, it's going to take an enormous movement. See, I'm not the only guy that thinks this stuff, but we don't have a way to congeal it together, and we need a point of the spear if we can. I really think a law school like that would be
great.
Outstanding.
We definitely need it. We definitely need it. Well, hey, I appreciate what you do. I appreciate you coming on. Thank you for being with us tonight. Love to do it again. I need to have you on to do one on jury nullification. We've talked about that before, but
sure.
I still need to get you on. So that will probably be the next thing.
Okay.
Well, hey, thanks
we
again.
remain ready. Just give me a little advance notice and we'll be ready.
All righty. Well, hey, thanks again. I appreciate you coming on.
Thank you.
You have a good night.
All right.
Thank you, Jennifer. Appreciate you as well. We're going to go ahead and cover the Informer report and some announcements, and we got to try to finish up here in just a little bit. All right, the Informer report. Okay. And it starts now. The Tennessee legislature failed to pass any The Tennessee legislature failed to pass any of the several election integrity bills filed in the General Assembly despite having a Republican supermajority. Simple bills like not allowing those that live overseas whose parents may have been Tennessee citizens, but they themselves have never lived in Tennessee, from voting. What an idea. Or not allowing those that don't meet the constitutional definition of a natural-born citizen to be on the ballot for president in the state of Tennessee. Or how about the bill requiring county election offices to verify citizenship through SAVE, which is a federal database, before adding new voters to the rolls? All failed, all killed by our utterly worthless GOP supermajority. Speaking of utterly worthless, let's talk about Senator Todd Gardenhire. The following information can be found on the Tennessee Firearms Association and was written by John Harris, but I'm going to go over it here real quick. As chairman of the Judiciary Committee, March 23rd, 2026, Chairman Todd Gardenhire took it upon himself to continue, which means basically punt to next year, several of the bills that were pending in that committee to an unspecified date in 2027, a date far beyond the last possible date for consideration in the 114th General Assembly. Reportedly, he did not alert the other committee members that he was going to do this, and by his actions, he took it upon himself to deny the other 32 senators the authority to even consider and debate those bills. Worst of all, the 9 members of the Senate Judiciary Committee, 7 of them are Republicans, including Gardenhire. The other Republicans are Bobby Harshbarger, Kerry Roberts, Paul Rose, John Stevens, Brent Taylor, and Don White. So far, there is no public evidence that any of those 6 have complained about Gardenhire's actions, that any of those 6 have challenged it with Senate leadership, that any of those 6 have taken action under Senate rules to remedy Gardenhire's abuses, or that any have taken any other action to bring the bills back from the future to be addressed here and now. Further, there is no public evidence that the lame duck Lieutenant Governor Randy McNally or Senate Republican leader Jack Johnson, who would love to be the Lieutenant Governor, has done anything to remedy Gardenhire's abuses. Their silence raises questions about whether leadership supported or acquiesced in these actions. And Gardenhire's abuse is not solely a Senate issue. It also impacts the viability of the companion bills in the House, rendering those moot as well. other than for election propaganda purposes, that is. But like the Senate, House Republicans and House leadership have effective tools to remedy his abuses. The House supermajority could, for example, declare any remaining Senate-sponsored bills dead in the House. The House, as the originator of the budget, could essentially table all budget work conditioned on the Senate's reversal of Gardenhire's unilateral actions. The House could hold session open indefinitely by delay tactics in an election year to force the Senate to remedial actions on this issue. Will it do any of those? Certainly not if Gardenhire's actions were not unilateral, but were instead part of a wider Republican conspiracy to disregard the constitutional rights of citizens and the Hughes versus Lee ruling. Guess we'll see how that turns out. House Bill 1971, Senate Bill 1958, they have both passed through the committees. As a matter of fact, House Bill 1971 was passed on the House floor today. There were 38 Republicans that voted against it. I encourage you to go to Tennessee stands. They have the list. I'm sure some other entities do as well. But look, and you'll notice when you look at the House members that the more conservative House members voted against this. And the usual suspects and the rhinos voted for it. Now, it still has to be voted on in the full Senate, and that is not on the schedule yet. It has one more. It has a Rules Committee to go to, but it's not going to die in the Rules Committee. And you'll hear more on this. I know they do have a memo out because they did put an amendment on it, but the amendment really does not address the issue. It's really more smoke and mirrors is what it is, trying to camouflage it and tell you that, hey, we took care of the problems. That's not the case. Believe me, I've looked at the amendment, but you'll hear more on that. And the only thing we can do right now is contact your senator and tell them to vote against Senate Bill 1958 whenever it comes to the floor. Now, for those who end up voting for it, this should be something you look at this year, especially if they have a challenger. If they have a challenger and they voted for this legislation, well, then you should be supporting their challenger. Odds are, okay, especially if it's in a primary. That's really what you need to look at. We have to punish these people when they do this kind of garbage to us. The nullification bill failed in the Senate, but Senator Briggs, the chairman of the State and Local Government Committee, also failed to allow any debate. He went straight to a vote, claiming that everyone was familiar with the bill and didn't need to discuss it. He said that despite the fact that there were 3 new members on the committee that were not there when the bill was last discussed in 2024. Briggs is another worst of the worst that needs to go. Hopefully, Kent Morrell can make that happen this year. And that wraps up this installment of the Informer Report. If you have a news story that you want to alert us to, be sure to send us an email at tninformer.tv@gmail.com. I want to thank the audience for taking the time to watch our program tonight. It doesn't cost anything to subscribe, so please be sure to hit the like and subscribe buttons, as well as the notification bell so you never miss an episode. We appreciate your support. Our goal is to have 1,000 subscribers. We didn't quite make it last month, but we need a little less than 50 or a little less than 60. So if you haven't subscribed, please do and share us with your friends. Check out our audio podcasts on iHeartRadio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, tninformer.com. Find and follow us on Facebook and Twitter. Got a couple of announcements here. The Stewart-Henry County chapter of the TFA will meet for a special event Tuesday, March 31st. That's tomorrow night, 7 p.m. at the Stewart County Visitor Center, 117 Visitor Center Lane off Donaldson Parkway, which is Highway 79 in Dover. It's right in between Dover Elementary and Mamma Mia's restaurant. Our featured speaker is Tiffany Boyd, former tenured public school teacher, founder of Free Your Children, which seeks to equip citizens to defend parental and educational rights through Christian discipleship and constitutional advocacy. An education consultant, podcast host, and an education researcher, she is a monthly contributor to the Murfreesboro Pulse. Her work has been featured in the Daily Wire, Liberty Sentinel, WorldNet Daily, WSMV, the Christian Post, and the Blaze. Membership is not required to attend. All are welcome. Join us next Monday, April 6, 7 p.m., when our guest will be Rebecca Terrell, a contributor to the New American Magazine since 2009. She joined the staff as a senior editor in 2022 with a focus on health, energy, and environmental issues. Her background includes experience in both public and private sectors, as well as education and healthcare. She served as a legislative aide on international affairs to Congressman Ron Paul and authored his American Sovereignty Restoration Act to withdraw the United States from the United Nations. She joins us to discuss government-produced Hunger Games. It will be interesting and informative. So please take the time to check out the other shows. Join us next week when we have her as a guest. Some of the other shows we have are brought to you by West Tennessee TV. You go to westtennesseetv.com or myparistv.com. You can find links to the Mike Weatherford Show and Sportscast with Jeremy Bucklew. Tomorrow, Mike welcomes in Commissioner of Agriculture Andy Holt to find out all about everything behind our food supply and what you need to know. That should be an interesting show. Then on Sunday, April 12th, Jeremy returns with his one-year anniversary show with guest coaches Dylan Poole and Corden Height. That's it for now. Good night from Paris, Tennessee, that is.